So now I think it's for me to introduce Paul Cowan, our next speaker. Thank you, Paul, for agreeing to speak. Now, he's recently been described as best in his class and someone who thinks outside of the box. So it's very helpful for us to know that he's going to be able to share that insight and outside of the box thinking when he tells us about tort claims in the contractual environment. Thank you, Paul.
Thanks very much, Rachel. Well, hopefully the tech is succeeding and you can hear me. I'm not on mute, I believe, as Annalise was just talking about. And if nothing else, I think I can promise you the next 40 minutes will be free of COVID, as well as references to Meghan and Harry and other such matters that ail us currently. Now let's see if I can get the slides going. Right, hopefully you can see the slides. Somebody please interrupt me if that's not the case. So let's get into it. So tort claims in a contractual environment, and I just want to go back to some very familiar but significant basics before we go anywhere else, in that just to understand and recall the difference fundamentally with contracts being the enforcement of positive rights and duties that the parties themselves have created versus tort, and particularly the tort of negligence, where duties are imposed as a matter of law and policy to avoid or restrain harmful conduct, and also as a mechanism for compensation to be paid. Now, obviously, in our area of construction, that is dominated by commercial contracts, the JCT, NEC, and everything else for that matter. So that provides, obviously, the lion's share of our area of practice. But it is fair to say that tort claims have encroached and continue to do so. And actually, one of the reasons why I thought of this topic is anecdotally as regards my own practice. Over the last year or so, I seem to have encountered this more regularly perhaps than previously, but perhaps I've just been lucky or unlucky in that respect. So continuing with some familiar basics, the main vehicle in which tort claims will be encountered in construction practice is in the field of concurrent liability as the main vehicle. And obviously we have the Henderson and Merritt primary authority in this regard, which upheld the existence of concurrent liability for professionals in negligence alongside their contractual liability. And that was not a given. And as we'll see in a moment, there were certainly countervailing views which exist in this jurisdiction and in others. But within its four corners, again, this will be familiar territory, this was based upon the notion of an assumption of responsibility by a professional to protect his or her client from economic loss, and that it customary arises in relation to where there's a professional retainer or in such other close relationship in circumstances which are described as akin to contract, harking back to the phrase from the old Hedley-Byrne and Heller case law. In terms of justification, that as set out by Lord Gough in Henderson, that there were a number of justifications given for permitting concurrent liability, that there may be, for example, an assumption of responsibility by a professional outside of a contract, for example, free advice, but nonetheless expected and relied upon to be discharged professionally. And he also emphasized in particular the rather more generous law of limitation that exists for negligence claims against professionals, for example, the date of damage as opposed to the date of breach, as well as the use of the Latent Damage Act, which again particularly concerns us in construction practice. And a related point to that a paying client under a contractual regime should not be in a worse position to claim than would be somebody claiming extra contractually purely in tort, who hasn't given any consideration for the services that they're receiving. But it's fair to say this doctrine was not without its critics, and certainly among the leading critics, you can refer to Sir Rupert Jackson's 2014 paper for TECBAR and the SCL, which I've given on the screen. And certainly I don't intend to re-argue his case, and he will do it better justice than I will. But certainly it is a characteristically learned comparative law commentary going all the way back to Roman law from Gaius and Justinian, who incidentally I think should be dear to our hearts, because if memory serves, he was under his leadership, he was the first to permit lawyers to start charging their clients. But coming back to the issue, Sir Rupert forcefully argues that contracts should not, and generally don't, generate duties of care in tort which mirror the contractual obligations. And he further argues with some force that any problems which may exist with the law of limitation shouldn't be solved by contortions, as he puts it, within the law of tort. They should be dealt with head on as regards limitation, law and statute. Be that as it may, whatever we may think of it, it's here and it's here to stay, and we've got to deal with it. So what I want to do in the following time that we have is to highlight some particular features and also move on to some interesting application in practice, including some recent practice. But starting again with just situating us within the landscape. Again, this is in Henderson. One of the key limitations of the approach is considering claims of assumption of responsibility within the contractual matrix. And I put on screen the key slide, in that in many cases in which the contractual chain is comparable to that in the present case, it can be proved to be inconsistent with an assumption of responsibility, which has the effect of shortcutting the structure put in place by the parties. And the courts are very sensitive to avoid doing so. And he gives the express example from construction practice, in which an owner generally has no claim against a subcontractor in tort, because the parties have set out their contractual structure, in which the owner looks to the main contractor for his or her remedy and then downstream the chain rather than direct remedies. And the rationale for that, which I think again is conceptually interesting before we look at its application. Again, staying with the subcontractor example, there is generally no assumption of responsibility by the subcontractor direct to the owner, the parties having so structured their relationship that it's inconsistent with any such assumption of responsibility. So just stepping back for a moment, and I would venture that there's an inherent conceptual, whether it's a tension or a blending, I sort of leave to people to consider, but tort is an objective consideration of the factual and contractual circumstances to consider whether there was an assumption of responsibility by, typically speaking, the professional in question. But that is a voluntary act, and the parties' contractual matrix is something which they intended to do or not do, where contracts are or not put in place. So I think there's an interesting confluence between the typically objective consideration of the facts as conflated with what the parties intended or did not intend to do in the particular case, to judge whether it can be fairly said that there was an assumption of responsibility, which should sound a remedy in tort. Continuing with concurrent liability and seeing it in practice, a couple of relatively recent cases, a classic example in the Burgess case was where the architect agreed to provide services free of charge, but on a professional footing and with reliance by the claimants. So the classic example of an assumption of responsibility outside of and free of contract, which nonetheless was considered appropriate to provide a remedy in the law of and the tort of negligence. And that case also exposed a difference, which I'll return to in a few moments, between the position of construction professionals and the position of contractors, builders, in which the latter was not permitted to be sued in tort, and the remedy could only be in contract, which in that case didn't avail. And again, as I say, I'll come back to that in one moment. Another very much more recent example is in the Valley Brook case, in which effectively an architect under a previous retainer had produced drawings in relation to a proposed development, which did not proceed with that earlier developer client. And a purchaser of the property was interested in purchasing it and essentially picking up the development from where it had been left off. And on the facts, the architect for the prior developer agreed to provide drawings together with discussions and advice to the incoming purchaser. There was no contract in place, but on the facts, the court found that this was akin to a client relationship, even if it didn't quite get over the line in terms of an actual instruction, and which was sufficient, excuse me, on the facts of that case to give rise to an assumed duty of care. So both of these are positive examples of how the courts have used this in practice to provide a vehicle for remedies in extra contractual situations. Equally, there have been a number of cases which have looked at concurrent liability in which the duty of care has been rejected due to the contractual matrix. And in our area of practice of construction, a good example of that was in the Galliford Try and MacDonald case with the judgment of Mr. Justice Aikenhead, and in which what was going on was an incoming contractor had priced for the job, he'd received information, this was a D&B project, and he priced in on the basis of the information that was provided and with the design information that had come from the owner's consultants. And one of the consultants was the owner's engineer concerning the piling design, the ground improvement works design. And as is common in design and build projects, it had been intended for the engineer's appointment to be novated over to the contractor in order to provide such a remedy as in the circumstances which happened, in that there were problems with the piling design which caused increased costs and delay, which the contractor was otherwise facing, and he wanted a remedy against the owner that he regarded as responsible. And in a very lengthy judgment, which, like many of these cases, they're rather fact-dependent. But what I would pick out was that a key part of the judgment was to consider the factual and contractual matrix, within which the court identified the important factor that the contractual nexus or lack of contractual nexus between the parties said to owe the duty and the parties said to have been owed it. Now, in this case, the parties, it was found as a clear fact that the parties had intended that a legal remedy would be provided through the mechanism of a novation agreement, as is typical practice in D&B. But for the reasons in that particular case, such an agreement didn't happen, it wasn't concluded. And that having been the case, the court expressly held that as the parties' contractual structure had anticipated that would be the mechanism through which any such rights would be conferred, but were not conferred because the parties didn't conclude such a novation agreement, that it was not the role of the law of tort and assumption of responsibility for such duties to be put in place in default of the parties having concluded their own agreement, in order to fill the gap, as the phrase is sometimes used, and that the law of negligence, certainly in this case, was not going to do that, and therefore no remedy was provided. Another recent area, just moving perhaps, staying with it, but slightly wider, is where contractual limits on tort liability. So rather than necessarily the contractual matrix giving rise to whether there is or is not an assumption of responsibility, that the terms of the contract itself that does exist, how they may shape the existence or scope of the duty of care. And there was following a case, a non-construction case called Arrowsmith. This was seen in similar circumstances in the case which is on the present slide, of BW Trading and Integral Geotechnique, a TCC case from 2018. And basically, cutting a lengthy story short, what was going on is that the defendant carried out, it was an engineer, carried out a geotechnical investigation of the site for the seller of a property. And it was agreed that a copy of that report would be provided to a purchaser, an incoming purchaser of the site. And because of claimed issues with the content of the report versus the conditions on site, a claim was brought by the incoming purchaser on the basis of tort only, because there was no contractual remedy against the engineer, for an assumption of responsibility in circumstances where it was known by the engineer that that report was to be provided to purchasers who may well be relying upon the report. And amongst the features in this case, one of the points which I found most interesting was that the court's emphasis, and it looked at the terms of appointment of IGW, and this is the terms of appointment between the engineer and the seller. So not between the engineer and the purchaser, and because no such terms existed. And what the court emphasized was that the purchaser was or should have been aware that such an appointment existed on the basis of how the engineer was commissioned to undertake the investigations, and that it was or should have been reasonably contemplated that that appointment would contain material limitations. And in this particular case, it contained limitations on liability to third parties, for example. And it also placed emphasis alongside the emphasis on looking at the terms on which the engineer was engaged, that the purchaser took no steps to confirm the legal basis on which it could rely upon the report, other than the fact that it was given the report to look at. And in particular, that there were no attempts to assign the report or procure an assignment of the engineer's appointment. And in this particular case, that was sufficient to negative the claim for an assumption of duty of care, and therefore no liability was attracted in tort. And the court also went further and ventured as what must be an obiter dictum, that even if there had been an assumption of duty of care, it would have found that the scope of that duty of care would have been constrained by limitations within the engineer's appointment, such as, for example, caps on liability, even though the evidence was that the purchaser had not actually seen a copy of that particular engagement in question. And this then leads, or has led on, in my own practice, in a more recent case, where this was revisited in further detail, which is RSK Environment and Hexagon Housing. And the judgment was before Mrs. Justice O'Farrell. I was counsel for the consultant in this case. And I should hasten to add, the litigation is continuing, but this much, I think we're on firm ground and has been decided so far. And in short version of what I regard as clear and not disputed facts, that the engineer was carrying out a geotechnical investigation of the site, similar to the case we just looked for. And the engineer was asked to issue its report, not only in the name of the contractor, who was its immediate instructor, the incoming D&B contractor, but also to issue it in the joint names with the incoming purchaser of the site, which the engineer did. Works were then carried out. There were problems in the ground, and then claims were then advanced in relation to the ground investigations for the costs that flowed from that. And the claim by the purchaser was asserted in tort only, on the basis that this meant, and it was advanced expressly on this basis, that by proceeding only in tort, this meant that any contractual limitations in the engineer's appointment would not apply. In other words, that unlimited tortious liability could be claimed, obviously subject to proof of negligence and the rest of it. And this point of principle was an entry-level dispute between the parties, because there were contractual limitations which were significant and which would immediately transform the ambit of the dispute from potentially having more digits than would otherwise be the case if the contractual limitation would apply. And therefore, what was brought forward was effectively to test the proposition that in circumstances where there was only a tort assumption, an assumption of duty of care in tort, to what extent would or could the contractual limitations of the professional's engagement apply to limit tortious liability under that assumed duty of care. And before we look at the judgment, it was interesting to just consider the position that would existed prior to this, which was the subject of quite a bit of research. And I should say that where you're dealing with concurrent liability, where there's a contractual retainer of a professional together with the assumption of a concurrent duty of care in the sort of classic Henderson sense, the cases are pretty clear that liability in contract and tort is generally speaking coterminous, including limitations on liability. So in that sense, at least as regards concurrent liability, there's nothing magical to tortious liability being constrained by contractual limitations or exclusions. But where you're looking at tort only, the field, certainly the position at law, was rather less crowded. And for example, Keating, in its current edition, expressed the view that there has been uncertainty about the effect of tortious relationships of contractual exclusion clauses. And reference was made, as is made in many of the commentaries that have touched on this, to Lord Brandon in the Ali Ackman case in the House of Lords. And that case was decided on other grounds and established the principle requiring a property interest in the thing in question in order to claim for it. But there was an argument that was raised by reference to Lord Roskill's judgment in Junior Books, perhaps daringly, given the position of Junior Books. And what Lord Brandon said was this, and I haven't put it in the slide, but he says, "I do not therefore find in the observations of Lord Roskill relied on any convincing legal basis for qualifying a duty of care owed by A to B by reference to a contract to which A is, but B is not a party." And it had been argued that this dictum effectively was rejecting the notion of how a contract between A and B could impact upon A's tort liability to party C. However, on closer examination of a number of key subsequent authorities that have touched upon or engaged with this, that the position was rather less robust than that. And actually, certainly as supported by those cases, that actually, I think that Lord Brandon's dicta was probably more related to the fact that he found that Lord Roskill's judgment in Junior Books was not authority for how contracts between A and B could impact upon tort liability to C, but not to say that it couldn't arise, simply that that particular dicta in Junior Books was not good authority to that effect. And this was looked at in various levels in the three cases that I've cited, and in particular, probably most usefully, certainly as was for my purpose, in the Killick and PwC case, which was notably populated, the court, Mrs. Justice Newberger, as he then was, and assisted by Lord Goldsmith on one side as counsel and Sir Sidney Kentridge on the other. And there was rich and very learned examination of the case law and principles, albeit on the facts of that case, the court didn't finally have to dispose of the issue, but certainly as obiter dicta go, it is of particular and close interest for consideration in this area. And my slides up, I thought they'd frozen there. So coming back to the case I was talking about of the engineer who provided a report, and this was the report in question without going too much into the facts. The report was provided making reference to this report is provided under the terms of the appointment document dated X, Y, and Z, but did not reproduce the terms. So in a nutshell, that was the factual matrix that existed. And on the point of principle, forgive the lengthy quote, but Ms. Justice O'Farrell said this, that the cases we've just looked at were concerned with the question as whether there was any duty of care based on an assumption of responsibility. But that question necessarily involves a determination of the nature and scope of any duty of care, and that a bare finding that a party owes another a duty of care is meaningless in the absence of findings as to the nature and scope of that duty. And then here, I think, is the key takeaway that I wanted to bring out, that in a commercial context, the nature and extent of a common law duty of care will be framed by the contractual nexus or lack of contractual nexus. Pausing there, so much I think is already clear from Henderson on down, together with the wider factual and contractual arrangements, including any stated limitations or exclusions from liability, and which was the position that was advanced on behalf of my client in this case, to that effect, that where, for example, referring back to the case we looked at earlier of BDW, where, as it was found in that particular case, and as a professional was undertaking duties under express limitations of liability, which either were known or could reasonably have been contemplated by the third party beneficiary of the tort liability, that the assumption that forms a key part of how and to what extent the professional assumed its duty of care in that particular case. So that was the key principle to take away from that. The other interesting topic, and there are obviously many topics in this, but I wanted to bring out the position of what Sir Rupert Jackson describes as the contractor conundrum. And I've referred to, again, with another regrettably lengthy quote, the Robinson and P.E. Jones case, which looked at the position of contractors as to whether they owe concurrent duties of care. And obviously this is in cases where it may make a fundamental difference if, for example, the contractual limitations have expired, but the tort liability, if there is one, may still be a runner under the limitation period. And before addressing the contractor, what Lord Justice Jackson emphasised in the Court of Appeal was that outside of the realm of professional retainers, it by no means follows that every contracting party assumes responsibilities to the other parties coextensive with contractual obligations. And he says such an analysis would be nonsensical, and then goes on to refer to the difference between contractual and tortious duties, and which is an important statement of principle, because otherwise it could be said, if this were given a maximum tailwind, if you will, that every party that undertakes duties or risks in a contract to another party, in that sense, is assuming responsibilities within the four corners of what's said in the contract. And Lord Justice Jackson was firmly rejecting the notion that contractual undertaking should give rise to tortious liability outside of the professional realm. And he went on then to address the position of the building contractor. And in this case, again, as I put on the slide, he saw nothing to suggest that the defendant assumed responsibility to the claimant in the Headley-Burn sense. This was a normal contract in which the defendant undertook to complete the construction of a house for the claimant to an agreed spec and in consideration for the purchase price, containing warranties of quality and so forth. The parties were not in a professional relationship whereby, for example, the claimant was paying the defendant to give advice or so forth. And that was the firm statement in that case concerning effectively a traditional builder. And this was cited in the Burgess case that we touched on earlier, in which this was accepted, this was referred to, again, by the Court of Appeal, that the contractor, a building contractor, does not ordinarily owe a duty of care to protect the employer against economic loss. And then on this sort of last slide, in which I sort of just leave a few thoughts and takeaways, the question then arises, as is seen with the rise and rise of design and build construction, certainly in UK practice, is that Robinson didn't address the position of a D&B contractor. It was dealing with a traditional procurement situation. And therefore, it is suggested in a number of quarters, including a tentative suggestion in Keating, that at least to the extent that a D&B contractor assumes design obligations, that he therefore should be treated like a designer in that sense. And at least as regards his design undertakings, that should carry a concurrent duty of care in tort. And that may be the right answer. But again, if I sort of venture a few thoughts on this, that I'm not sure that is it's a simple answer, or certainly as simple as that. And what's, as we've already looked at in the Robinson case, what's firmly emphasized is the position of a professional retainer as a particular circumstance in which concurrent liability is activated. And therefore, I would venture that it's not so much that the D&B contractor is undertaking design, which otherwise would be done by a design consultant. I think the question that would arise would be, is the contractor operating as a professional? Because, and in particular, a key distinction one also sees with a D&B contractor is very often, more often than not, the case that the D&B contractor is not actually undertaking the design. It is being done by his subconsultants and subcontractors. The D&B contractor takes the risk for it, but he's not actually doing it, which I suggest is a material distinction in terms of whether he is operating as a professional, in which the professional itself is discharging the service, and that may well provide some of the answer to the contractor conundrum when it encounters a D&B contractor. The other issue is one of potential anomaly or difficult practical distinction, insofar as it is found that a D&B contractor owes a concurrent duty of care, at least as regards design functions, because it's firmly established, including in the case we just looked at, or cases we just looked at, that as regards his construction obligations, no such duty of care arises. And the case says, and I cited the example of the Court of Appeal in the Belfield case, that there is very frequently a blurred borderline between where design ends and where decisions of implementation, workmanship start, such as, to use the Court of Appeal's analogy, a carpenter's choice of a particular type of nail or screw is in a sense a design choice, sometimes a very material choice, where you're into, for example, different types of metal, where there can be bimetallic, corrosion, for example. It may well be that the type of screw can be very significant indeed. And so, insofar as you have this mixed function of design and construction, and if it does give rise to a mixed situation in which the contractor has design concurrent liability but not construction, you can very quickly end up in a very mixed position. Another example, which I may have recourse with other people who may be listening on this video conference to consider, is where there is a claim of assumption of concurrent liability to third parties when parties such as consultants or contractors provide collateral warranties. Do they equally assume concurrent tortious duties alongside the contractual undertakings in the collateral warranties? And that's certainly may well be examined in a case that I'm involved in, which is currently being pleaded, together with, in fact, the position of the D&B contractor. But that maybe is for another day when that case has advanced further. And then finally, and I've looked at selected topics within a wide sphere, but there are also in particular topical examples that could be looked at within the development of a statutory tort, such as Section 1 of the Defective Premises Act, where I and many others in our field of practice are encountering with much greater regularity, particularly in the context of post-Grenfell cladding claims, in which this tort certainly has some scope for further definition and development. But that is literally a topic for further examination this afternoon, at which point I'll end at this point. Thank you very much.
Thank you very much, Paul. That was very informative.